chapter 3. Well, we're talking about concepts of crime. We're going to continue just a little bit of a review on Corpus Delicti and how that fits into crime. So let's start off with that. Give me your own version definition, your own words definition of Corpus Delicti. I'm sorry? Yeah, exactly. What makes up a crime? The things that make a crime, the elements of a crime. So we've described it a couple different ways. We've talked about just the actual elements. We also talk about convergence between mens rea and actus reus, so the thinking of a crime and the actual action of a crime. We're going to expand that just a little bit today, and we're going to talk about well, before I talk about what we're talking about, I do want you to remember this specifically because it is a Latin term. The actual, I want you to know the meaning of it, but I also want you to know the word-for-word definition of it. Body of the crime. Remember that. You should always, because it is a Latin term, you should know the English translation, and body of the crime is what we call it. It's what it's translated to. So again, we talked about if you have somebody thinking of a crime and then actually doing a crime, that convergence is necessary in order to meet the elements of Corpus Delicti. So if you think, okay, I have the intent to punch somebody in the face, and then you actually act on it, your body moves to punch somebody in the face, then now you have that convergence of those two elements. We have two more elements we're going to talk about, another convergence that we're going to talk about today, and that is an actual criminal act and somebody to commit that criminal act. Somebody who causes that criminal act to be committed and an actual criminal act. So those two things have to be in convergence for a crime to take place. So for instance, I used to own a ferret. My ferret and most ferrets love taking stuff. So I would put my keys on the arm of the couch. I'd come back a couple hours later, my keys wouldn't be there. And I would look around because the ferret has taken those keys and put it under the dresser or under the bed, because anything the ferret can find belongs to the ferret. And they love hiding things. It's just that's what they do. So we talked about last week theft. How do we define theft? Casually, not word for word.
Taking property of somebody else's.
Yeah.
With no intent to return it.
Taking property of somebody else with no intent to return it. So did we meet those elements as spoken when the ferret took my keys? Did the keys belong to the ferret? No. Did the ferret take the keys?
Yeah.
They're the property of another. And do you think the ferret ever planned on taking those keys out from underneath the dresser and giving them back to me? So based on those Corpus Delicti, do we have a crime?
Yes.
In theory, right? But we still have to add what we're going to talk about this week, that convergence of criminal act and somebody to commit that criminal act. Did we meet the definition, the legal definition of a crime? We said we did. But did we meet the legal definition of somebody to commit that crime? The ferret can't be charged with a crime, right?
No.
The ferret isn't a person, a legal definition of a person. So if we don't have somebody to blame on that crime, we can have all the crime we want, and it's still not all the criminal activity we want, and it's still not a crime by legal definition. So conversely, let's think of a scenario where we have the other one. So what are our two halves again? We need
Criminal act and somebody.
exactly. Criminal act is somebody that committed that criminal act. This happened. I'll give you an example. This happened. There was a gentleman who used to come into police headquarters at LAPD all the time, maybe once every couple weeks. They brought a letter. It was a signed confession for murder. Every couple weeks, he would come in and say, "My heart is heavy. I'm getting close to death. I need to get this off my chest. When I was younger, I killed somebody. I murdered somebody." And he had a very detailed description of how he did it, and it was a crime. I mean, he's describing a crime. and I'll fast forward for you. He's not describing like he's not necessarily describing like an act of war or something or a a metaphor for murder. He's literally describing how he killed a lady. And he would come in, he would go in and talk to the detectives, and he would walk out the front door again. Why do you think that is?
Because of the body, you have to do it to be dead.
Right. So in this case, that gentleman there was some mental illness going on, maybe some deterioration of the brain. Because I will tell you, when it comes to murder, folks take pretty good notes of people that are murdered and or missing. And so they compared every missing person in the area that he described, which was Los Angeles, so it's pretty easy to find. Every missing person and every dead body that was ever located, and none of them matched. And further research found out that he had some mental issues. So he confessed to a criminal act. We have a criminal act. He's telling you he did it. I'm sorry. He confessed to a criminal act. We have a person saying he did that criminal act, but we don't have criminal behavior. We don't have anything to compile that confession with, so we don't have a crime. We can have the person saying they did it without actually having done it. We don't have a crime. You can say you did it all you want. Still can't be charged with anything. Still can't be charged with that crime. There's always exceptions. You keep calling 911 to say you did it, you could possibly be charged with a crime there. But in general, speaking specifically of that crime, you cannot be, there's no charges you can file. So I want to give you the book definitions. I always like to give those to you just so you can comport them with the casual definition. So the two things we need: that a certain result has been produced and that a person is criminally responsible for that result. That's the book way of saying what we just said. You have to have a criminal act and somebody who committed that criminal act. The other way to describe very, very similarly, that you have to have the occurrence of a specific act that causes injury, and that someone committed that act that caused the injury. So when we say injury, you'll hear that term a lot in legal terms. Injury doesn't always mean a physical injury like an owie. In civil law, you could be injured by losing money. When it comes to arson, you can be injured by having your house burned down, even if you weren't in it. So we don't need to necessarily know who the victim is or the suspect. Even though I've told you we need to have a crime and we have to have somebody who's done it. So let's think of a way, and similarly, how about murder? If we find, we're all an investigative team, and we go to the woods and we find a body that is unidentifiable we're gonna just have to stipulate that there's no DNA left on the body, no prints, and for some reason we can't pull DNA out due to decomposition. And there's a knife sticking in the back where nobody could reach. Can we agree that that is probably a criminal act? A criminal act was involved in this body. Sure. So we probably have a murder, right? At this point in the story, do we know who did it?
Right.
Do we believe that there is a person who caused that injury? And in this case, it is an injury.
Yes.
Yeah. We don't know who it is. And we also don't know who our victim is. But we know that they are a person who was injured. Now, if we change that story and it's a deer or a bear or something like that, now we don't have a legal victim of murder. We have some other crimes possibly. At some point in the future, maybe you have an old man who walks into police headquarters and starts handing a letter saying, I dumped a body wherein I took off the hands, the feet, and the head, and I used this chemical to take away the DNA. Now we start putting those things together. Maybe we have somebody to attach to be the cause of this criminal act, the one who acted on that, the one who behaved in a criminal manner and now caused a crime. What do you think You think we can charge them now? Let's talk about that. Can that person be found guilty of murder if we never find out who this person is? Tell me about that. Do we need a named victim? No? Why is that?
Still a person.
Sure, yeah, exactly. By definition, it's a person, right? Do you guys know who the Branch Davidians are in Texas? The Waco siege? Tell me just a quick thumbnail sketch on that. What was that?
It was about the like a cult that was being held in Texas and they made a big FBI went there and made a big raid. I don't know what it was.
Right. So there were some folks that belonged to a church. Some people called them a cult, and they ended up the crime that they ended up engaging in at some point was they bought some guns, illegal guns from an undercover either informant or government agent, something along those lines. And in doing so, they broke the law, and the ATF and the FBI got involved, primarily the ATF. And the ATF wrote a search warrant and an arrest warrant. We're going to go in. David Koresh was the leader of this church. It was just outside Waco, Texas. The scandal, if you will, is that it was a very violent search warrant service. So initially, they went to go serve it. There was a shootout, and several ATF agents were killed in the service of that warrant. The ATF pulled back, surrounded the compound, and several days, if not weeks, went by where they just surrounded it, and it's very newsworthy. This happened in '93, I think. To give you some perspective, I think I was a senior in high school when this happened. So eventually, they had to act. They've got to take these folks into custody, and there was a very violent second service of that search warrant, whereas some tanks were used and some incendiary devices. Lots of buildings burned down. The church compound was on fire, and dozens of people, 88 people, I believe, were killed in that second search warrant service, or that second entry into the compound. I tell that story, one, because it's an interesting story, thinking about the dangers of law enforcement, but also the how to tactically serve warrants, your cost-benefit analysis on at what point, what are our options do we have to serve? If you were the ATF, now that you can see in the future and know this is what's going to happen, if we use these tanks and these incendiary devices, 88 people are going to die. Do you still use those devices to take these people into custody? It was the purchase of illegal weapons worth that cost? But then we escalate that. Well, also was the murder of several agents worth the cost of 88 lives? And today, standing in front of the classroom, I can't tell you one way or the other. If I was out on the scene, maybe I'd make a different. If I'm commanding the search warrant, I make maybe different decisions. I can make a more informed decision. But today, giving you just a thumbnail, for nothing better than a Wikipedia sketch of this incident, I can't give you the right answer. We have to think about cost benefit when we're in the law enforcement and the criminal justice world. Cost benefit goes in with sentencing or crime committals too. We talked about yesterday. If you were in one of my classes yesterday, we talked about how people essentially will conduct a cost-benefit analysis to determine whether or not crime is worth it. If I get caught, this is what's going to happen. But if I don't get caught, this is what's going to happen. Cost, benefit.
They illegally purchased the weapons because there's the crime there, but did they illegally purchase the weapons, or did they just purchase the weapons? Because if they just purchase the weapons, there's no crime there.
Correct. So in this case, there was an illegality to the purchase of the weapons. I couldn't tell you, without looking at the case, whether or not the weapons themselves were illegal when they purchased them, or they purchased them in an illegal manner. But there was a crime involved in the purchase of those weapons. But we have to do those costs in the world of criminal justice. I've never been involved in a search warrant of that magnitude. When I supervised LAPD specialized units, we used to serve search warrants all the time. And even those minor search warrants where we would infiltrate certain organized crime, underground casino type locations, that was going through my mind, the cost and the benefit. Is it worth the risk and the reward? What is the risk of kicking open a door and running into a location that you've never seen, very few people have seen the inside of? As a law enforcement officer, as a criminal justice practitioner, what is the risk of running into an organized crime location after you kick the door down?
Getting shot down.
You don't know the layout of it.
Exactly. Hopefully you have the right intel. Hopefully it's been infiltrated. In this case, it's been infiltrated by the right undercover officers and you have intel, hopefully, and hopefully they remembered it right. If somebody kicks a door down regardless of how much criminal activity you're involved in, if somebody were to kick your home door down, would it startle you?
I keep coming back to the Breonna, what's her name?
Taylor?
Breonna Taylor case, and that, you mentioned something the other week about.
Right. If you're not familiar with the Breonna Taylor case, there's a search warrant that was served. There's some controversy as to whether or not it was a no-knock warrant. And regardless, there was entry made. The defense by the suspect was, I didn't know it was the police, and he shot at what he believed to be intruders. The intruders, in this case, were the police serving a search warrant, who obviously shot back, and the bullets struck at least Breonna Taylor, if not him as well.
And it went wrong, the search warrant was made for the wrong apartment as well.
Well, there's some, yeah, there were issues with the necessity of a search warrant was questioned. Not necessarily the location being wrong, but was the location necessary to be searched? Was the evidence that was affiliated with that address still valid and things like that? There was still some connection, some nexus between the suspect that was being looked for, but the actual address, I don't believe that there was any indication they were going to find their suspect. So the question was, does this search warrant need to be served in this manner? That was how we always go back and we question things. That's how we do our job better. So if you do your job, especially on a dynamic search warrant or something like that, and even if things don't go wrong, we always do what's called a debrief at the end of that. And a debrief is just talking about what happened. And what I would tell my folks is there's no rank in debriefs. And it happens in tactical situations or even in the classroom. If you have a study group and you all take a test and you all get your grades back, there's no shame in saying, well, this is what I got wrong. And I used to do that with search warrants and other tactical situations with my officers. If we enter into a location and usually everything is successful, the bad guy goes to jail. But at the end, I realized, you know what? When we all ran into that location, I walked past an open door to get to this door, and I realized that was dangerous. I shouldn't have done that. And if I don't have the wherewithal or the maturity to admit that I made that mistake, how can I expect my officers to admit or learn from those mistakes? I should be able to use the mistakes that I made to help other people. Because what I say, you should learn from your mistakes, right? The only thing better than learning from your mistakes is learning from somebody else's mistakes, so you don't have to make them. Did anybody happen to remember the arson story at the beginning of the chapter? I want to talk about that a little bit. So, convergence. If not, the arson story essentially went like this. There was a house fire. The fire burned down the house. When the investigators went to investigate this fire, when they were done putting the fire out, they realized that a lot of personal stuff was outside the house. Either hidden in locations, buried in bins, like maybe had a garage or something, a shed was involved, where anything that was of value, like pictures, jewelry, the book even mentioned like sex toys, like just anything that these people value was taken out of the house before the fire, coincidentally. Also, if you know about fire needs it needs a heat, fuel, what's the other thing?
Air.
Three, what's that? Air, yeah, oxygen. Oxygen, fuel, and heat. That's the three things that make fire. So if you wanted this room, if you wanted something to burn in this room large enough, it's going to suck out all the oxygen in this room. So how could we ensure that something burns successfully in a room like this is enclosed?
Crack a window.
Exactly. Break a window, crack a window, open a door, give it an inflow of oxygen. Because we already have the heat and we already have the fuel, whatever's burning, classroom is fuel or whatever we're burning here is the fuel. Well, in this house fire that we were talking about in, I think it was Ohio, this house fire, the sliding glass door near where the fire started was cracked. So inflow of oxygen. What is this all, the totality of what I'm describing, what does it sound like?
Arson.
Sounds like arson, yeah. So they called in the suspects eventually confessed, and they filed charges and went to trial. Well, before the trial started, the defense made a motion to dismiss all charges because the corpus delicti had not been met. We need a criminal act, and we need somebody to commit that criminal act, right? Well, you notice I skipped over something. Well, I didn't skip over it. The investigators skipped over it. There was no arson investigation done. Other than the interviews, no evidence was taken. No samples. I'm sorry?
How did the fire start?
Yeah, no investigation to find out where or how the fire started. Was there an accelerant used? So all of that was skipped over because the suspect said, I did it. He confessed. So we should be good to go, right?
Because you have, you have all the items that was put on the side, you know, you have an act here that they remove all the valuable items.
And the act is an act, but not a criminal act. So we need a criminal act and a person to be responsible for that criminal act. So if we never took any evidence of a criminal act, if we never showed that it was arson, all we have is a fire. We have a fire, which is not against the law, and somebody who said they started that fire, which is against the law. What does that sound a lot like? Does it sound like the old man who's walking into police headquarters with a letter? Walking into police headquarters with a letter saying, I did it, but you have no crime to put that on. Had they done an investigation, had they gathered some evidence and actually proven that there was more than a fire, because a fire is not against the law, but an arson is against the law. So if you could have shown some accelerant or shown that these people opened that door, other than their confession, you have to corroborate it so that you have a crime that converges with a person responsible for that crime. In this case, all they had was a person and no crime because they never took the time to prove that a crime occurred. And now, when so much damage is done, you can't go back.
I was just reading the story and remember about the man that when he said from his wife, from the police, of everybody that he sexually molested his 2-year-old.
Mm-hmm.
They arrested him. They went on a trustworthiness course. Corpus, he didn't meet Corpus and left that. But they is trustworthiness a law?
The trustworthiness clause, we're going to touch on that probably on Thursday, so I don't want to jump ahead too much on that. But in general, it can be a mitigating factor for the confession, things like that. An idea that is somebody going to confess to something that it would be unreasonable for them to confess or is reasonable for them to have done. But it can't be a standalone. In that case, I'll have to look at that case and see exactly what evidence was in there. But in general, you still need something to corroborate that confession.
And then during trial, he took it back. He took his confession back.
And if you lose the confession, in this arson case, we'll spin that a little bit. So there's a ton of ways you can lose evidence. And we'll just say in this case, they had custodial restraints on. And what do we say? When is Miranda required? It's a two-pronged approach. You have to have in custody and interrogation. So we'll just say in this case, these folks were in custody and they were interrogated. They were not Mirandized, and they got that confession. The officers received that confession. Well, now they go to court and realize, oh shoot, I don't have that. That confession was taken away from me. Now what do we have? We have a house that burned down and nobody that said they did it. Do we have a crime then? It's even worse. How could they have bolstered that confession? How could they have made that case better? If the owners of that home were willing to tell them they did it, what is the next series of questions that would have helped that case?
How did you do it?
Exactly, how? How did you start the fire? Where did you start the fire? Take me to the room. Let's go to the shell of the house. Show me where you started. Show me what you started it with. Was there an accelerant? What was it? Where's the rest of it? Was there a time delay match? Did you light a fuse to a matchbook and that matchbook set the fire, which gave you time to leave, or did you start it right away? Things like that, where you could have some physical evidence that was recovered. Now you're corroborating that confession, and now you've shown that there actually was an arson to go along with the arson confession. Because like I said, otherwise we just have the guy confessing to murder with no murder.
You have to get all that information without reading the Miranda, right?
I'm sorry?
You have to get all that information from the without reading the rights of the Miranda, right?
Well, if we go back to losing those Miranda rights, you may lose that information as well. That's why a detailed investigation is key. There are some other doctrines called things like the inevitable discovery, where even if the way in which you received that information wasn't specifically authorized, if you were going to find it out anyway, then you can still use it. There's other doctrines in play. Four things I want, now we're going to go from two things that need to align to make a crime, and we're going to have four things. Causation, a resulting harm, the principle of legality, and some sort of necessary attendant circumstances. Just off the surface, causation, what does that sound like?
What causes it?
Right. What or who causes it? What that who did to cause it? We talked about transferred intent. Remind me again what transferred intent is.
You harm someone with intent, with no intent to harm them, but you were going after to harm someone else.
Right, right. So if
Your intent was to harm someone else, but it injured someone else.
right, if I intend to, if there's a person in this chair and I intend to commit a crime against them, we'll say I intend to throw this mouse at them, but I'm a very bad shot and I hit this person. Did I commit a crime?
Yes.
So let's take the two. We need a cause, a person to a criminal act, and a person who caused it. The person who caused it is pretty easy to come up with. That's me. What was the act that I did? The criminal act that I did?
You picked up that mouse and throw it at that person.
I'm not throwing it at them. Some sort of assault, maybe a battery, depending on the size of whatever I threw at them. Maybe an assault with a deadly weapon. That is there's some sort of criminal act that went. Those two converge: a criminal act and a person to be blamed for that criminal act. That was easy. But I meant to hit this person. Am I still guilty if I hit that person? Transferred intent. The intent still applies.
Mhm.
But let's take it a little step further. That's transferred intent, but let's talk about what if instead of me just missing, I have pretty good aim when it comes to throwing electronic mouse at people. I don't want to say I would have gone pro or anything, but I'm good. So I go to throw a mouse at this person, but the air conditioner kicks on. And it blows the mouse hard enough, and now you're hit.
Still responsible.
It wasn't an accident. I didn't miss throw it, but I couldn't predict that, right?
Still responsible.
Right. Why am I still responsible?
Right? But you were still intending to harm someone.
Should I have known that somebody was going to get hurt or injured, right? You don't need medical attention to be injured. Just merely getting hit by that is an injury, a legal injury, because you're being harmed. Should I have known that somebody was going to be harmed when I threw a mouse?
That was your intention.
Right. I wanted to harm somebody. So it's reasonable to assume that even if I didn't harm the right person, I am the cause of her being harmed. But what about the air conditioner? Isn't the air conditioner also a cause?
factor, but television is.
But if we're listing out all the different reasons, what about this? Right as I'm throwing that, I'm gonna make it even more complicated. Right as I'm throwing that, Randy comes through the door and he flips the switch for the air conditioner. I knew the air conditioner was off. I knew that I was gonna hit this person. I throw it, and then Randy comes to the door, flips on the air conditioner kicks on super fast, and then throws it and hits Miss Polk, right? No. Carolyn. All right. So, is it Randy's fault?
No,
Is Randy a cause?
no, it's part of a cause, but it's not
There we go.
intended, it wasn't intended.
So you can still be part of the cause
Mhm.
without necessarily having the culpability that goes along with that. You could be what's called a proximate cause. Just because you're a proximate cause doesn't mean you're the one to be necessarily liable for that crime. It can be part of my defense. Maybe I go to, when I do go to trial, it's not my fault. I'm gonna take this person. Really, if you guys should be blaming somebody, you should be blaming Randy. If he hadn't come in here and turned on the air conditioner, then nobody would have got hit. Right? In theory, do you think that defense or excuse is going to hold water?
No.
Let's break down why. I agree with you. I do also say that Randy's a cause. I'm gonna go to my grave saying that, but is Randy gonna go to jail for it?
No.
Or am I gonna get off even? Because what do I care what happens to somebody else? I just care about me getting off, right? So I'm gonna back up to what I said a couple minutes ago. I'm gonna reiterate it. Was it a reasonable expectation? Should I have had a reasonable expectation to believe that if I threw this mouse at this person, that somebody was going to get hurt? When Randy came in here, was there a reasonable expectation that Randy thought, if I turn this air conditioner on, somebody's gonna get hurt?
No.
That's the difference. That's how you separate those two ideas.
What's the difference between transfer and proximate cause?
They're related. Transfer intent doesn't necessarily need to have additional proximate causes stuff. I can just miss. There was no other cause other than me missing the reason I hit that. Proximate cause is an additional factor that caused somebody else versus your initial target. Or it doesn't have to be somebody else. Maybe I didn't realize that. So we have something called the had not rule that applies to this. Had not have been for what you did or the suspect did, then this bad thing wouldn't have happened. But the had not rule, again, has to have a reasonableness to it. I'll write this on the board because I want you to know there's a lot of Latin. You may see them. Sign quonon, scene quonon. That's a Latin term for the had not rule. Another thing you'll hear it called is the but-for rule. But for what you did, nothing bad would have happened to this person. So going back to my example, the throwing the mouse, had not rule, had I not thrown that mouse at all, then she wouldn't have been struck and injured. And again, remind me why, because had not Randy turned on that air conditioner, she also wouldn't have been struck, right? So why isn't Randy liable again?
No intent, and what he did.
True. But also, it's not reasonable to expect that his actions would have caused that. So let me,
That's proximate cause.
yeah, let me change my scenario up a little bit. Maybe I'll help clear this up. I'm gonna change. There's nobody in any of these chairs. And I shoot a very, very, very light bullet at this chair. And then he comes in, turns that air conditioner on, and blows the bullet, and it strikes her. Is it reasonable to believe that if I start shooting a gun in a classroom, that somebody could get hurt?
Mhm.
Is it reasonable to believe if I turn an air conditioner on in a classroom that somebody's gonna get hurt?
No.
So of those two actions, those two behaviors, which one truly meets the had not test?
Turning on the light.
The turning on the light was a contributing factor, yes.
Mhm. Had not.
I'm sorry, turning on the air conditioner was a contributing factor.
Well, had not it been for you shooting the gun, that one would.
Exactly. Which one of those two, turning on air conditioner, is far more reasonable behavior? It is far less reasonable for me to shoot a gun in the classroom, and that means I had not ruled, because had I not done that, then nobody would have been hit. So we'll take away the transferred intent portion of it, where we don't always get confused that the had not ruled needs to be with transferred intent. I use that as an example, but we have no intended victim for our actions and still be criminally liable. I'll say that again. You don't need an initial intended target to have criminal liability that meets the had not rule. Because if I do something that reasonably would have been expected for somebody to get hurt, even though I didn't intend for a person to get hurt, it still meets that. Regardless of what happens, if somebody opens a window, or you could have a whole chain of events. We could make up the craziest story ever. We could, I'm shooting a gun over everybody's head, which is unreasonable, right? But I'm not meaning to hit anybody. And then the window breaks because I'm shooting a gun. And somebody outside screams. And everybody over here hears somebody screams and stands up and sees who's screaming, and then they get hit by the next bullet. Like, just crazy stories. Is that person screaming a proximate cause to anybody getting shot here? Yeah, they're proximate cause. But are they criminally liable?
No.
No. They caused, in a way, somebody to get shot. Their screaming caused that it was a part of that chain reaction. But being in that chain is not necessarily being criminally liable. Now, we can muddy these waters even further, because in these examples, there's nothing stopping that person from also doing something criminal and unreasonable. But I'm keeping it very clean when I tell these examples, just to show the difference. But remember, there can be multiple people liable for a crime if multiple people are doing unreasonable proximate, or engage in unreasonable proximate cause. In general, though, what you're going to see as examples is one person criminally liable and all these other factors that are proximate causes. But what you may not have heard about this. So many years ago, I was a young officer. There was a shooting call that came out in Los Angeles. I believe it was the Newton area of Los Angeles. Jose Pena was the name of our suspect. Jose, for some reason, decided to engage in criminal activity that day and have the police called on him. Eventually, he barricaded himself with a gun, and SWAT was called. He was inside that house with his 17-month-old daughter, Susie Pena. At some point in the day, in this barricade where he's got a gun and the house is surrounded by officers, Jose decides to come out of the house with his 17-month-old baby in his arms and a gun in the other hand. And then he starts shooting, and he shoots a police officer right in front of his house while holding his baby. Any guesses what happened next?
You got to.
Yes. Unfortunately, Susie, the little baby, got shot also. Not by Jose, by the officers. Regardless of the outcome, the civil outcome, let's discuss causes. Who's criminally liable? What are the proximate causes? What? So
He could have got charged for that. She did not.
tell me more. What? So how is Jose a cause to this? Give me the factors.
Well, a police
was
were
shooting
there
at the
for him,
cop.
and then he brought his baby outside, and he shot at somebody else, making other people fear for their life and he needed to do stuff.
So he had the gun. He decided to bring the baby, and he shot him. Which of those behaviors would we say would be unreasonable behavior? Having the gun? Okay. Anything else unreasonable? Is bringing a baby to a gunfight?
Maybe, yeah.
Yeah, so
Yeah,
gunfight.
but if he didn't have the baby, chances are the baby would have got shot.
There you go. If he didn't have the baby in his arms, so had not he had a baby in his arms, the baby wouldn't have got shot. Can we agree on that?
Mhm.
We're not saying it's going to pass the had not test, because not everything that had not, because had not Randy turned on the air conditioner, you would have got hit by the mouse, but it still doesn't make criminal liable, but it still means that had not, so had not he brought a gun, had not he brought a baby to a gunfight, and what else? Had not he shot a cop right in front of his house? Those are all, are any of those behaviors reasonable?
No.
What about the officer that, what wasn't the officer that got shot that returned fire? What about the officer or officers that returned fire? Are they a proximate cause or a cause? Are they any cause to that baby getting killed? Absolutely. And we're not gonna, I'm gonna leave it a discussion. I'm not gonna necessarily give you, because the legal gray areas of these types of situations, regardless of how that case turned out, are always up for debate. What do you think? I mean, who is our criminal, who's criminally liable and what's a proximate cause? Do you think that officer should have some criminal liability?
No.
The officer, so we'll say this officer got shot and these three officers over here returned fire, struck Jose and Susie. Should they be the primary cause of Susie's death? What is, if not, then we need a primary cause. What's our primary cause of Susie's death? Because their bullets are the ones who hit Susie. Jose? Even though Jose's bullet didn't touch Susie.
Yeah. What I have to that scenario, want to know, is that both cyanide clause, cyanide clause and proximate clause? Is that both?
This is just a Latin term that translates over to the had not. So we use the had not test to determine what's a proximate cause and what's a primary cause. So in this situation, essentially, this is just a poll now because we're discussing it to determine what you guys think. And it seems like, if anybody wants to argue the other point, is there anybody who believes that there should be some sort of liability on the officer? These three officers that fired, all three of their bullets, well, just to make the story simple, all three of their bullets struck Jose, and all three of their bullets struck Susie. Or we just take away the three. There's one guy. One guy got shot. One officer got shot. One officer returned fire. That officer's his bullets hit Jose and hit Susie. Is there some liability on that officer? In what way? Okay. I mean, that's absolutely. Had they not returned fire, Susie would still be alive. I can't argue with that. Yes.
Had he not brought her out there, she would
It would still go back.
Or return
Yeah.
fire.
It would still fall back on
It
Jose.
could literally go either way, determining like the whole situation, how everything happened, like, did the officer need to protect himself? Or?
What options did the officer? Were there other options that the officers had?
Yeah,
What other options could the officers have taken? Okay, so in that scenario, I'm not gonna change it up. I want to keep it consistent for that scenario. What else could the officers have done? So you and your partner at the scene, take away the fact that there's a team there. You and your partner at the scene, and your partner goes down. Jose shot your partner. Obviously, you can return fire. That's one option, one physical option. I'm not saying legal option. One physical option is you can return fire. What else can you do? Take cover. That's another physical option.
or you can die.
Or you can die, or you can not take cover and you can get shot. That's another physical option.
Chances are he's gonna shoot you too. He's not just gonna shoot one officer and leave you there to take him out.
So the idea of this is a very, I want to present this scenario because it's a much muddier scenario than Randy and me with the mouse and Randy. This idea that the proximate cause is such a fluid idea. The which came first, the chicken or the egg type of thing. Sure. Did him bringing Susie to a gunfight? Obviously, it literally came first. But is that the cause? Is him shooting at the officers the primary cause? Or should the officers, was it reasonable for the officers to have better aim? Depending on different schools of thought. I'm not saying these are the right answers, because there's a lot of folks who are going to say things like, you'll hear thoughts like, why didn't they shoot him in the leg type of arguments, which later on in the semester we may get into why those aren't the most reasonable arguments. But in this scenario, there's a ton of arguments we can throw out. That doesn't mean they're right or valid, but I want to hear them. I want to have them up on the surface. So you could try to shoot him in the leg and possibly unsuccessful in that endeavor, A, missing, or B, not stopping your target. But that is a physical, if not a tactically proper decision, but it's a decision. You can take cover and not return fire. You can not take cover and get hurt. You can fire back and hit Susie. Like there's a ton of different options, and each one of those options comes with a new had not decision. Had not I shot back, or had I not taken cover and not stopped the suspect, then maybe my partner would be alive.
In our reality, I believe that, the police officers would lose in a civil case.
In that case, you think they would lose? Depends on,
And
obviously, it depends on the
reality
jury.
of living today.
And that's the difference, that may be something you want to discuss in your paper. If I were to bring it all back again, in your paper, when it comes to the difference between civil and criminal law, maybe the had not case, the sine qua non doctrine, maybe has different applications for civil versus criminal liability. Maybe something worth researching. You need 3 references in your paper at least. Maybe you look in the library and find some references for civil had not law versus criminal had not law. Right? What are your questions today?